And the next case we have is Vanessa Velasco Ortega versus County of Okanagan. Isaiah Holloway and County of Okanagan. I hope I'm not mispronouncing the county's name. But Okanagan. I apologize. See, you are.
Good morning, Your Honors. My name is Amanda Keene, and I represent the appellant Isaiah Holloway. I'd like to reserve 5 minutes for rebuttal, if I may.
Okay.
The issue before this court is whether the district court erred when it dismissed defendant appellant Holloway's motion for summary, or when it denied defendant Holloway's motion for summary judgment to dismiss plaintiff appellant's 14th Amendment equal protection claim, finding quality immunity did not shield Holloway from liability on that claim. As this court is no doubt aware, in order to establish qualified immunity, the court must find the state actor's conduct clearly violated and a statutory or constitutional right of the appellee. And under this standard, the district court's denial of qualified immunity was error for 2 reasons. First, the appellee failed to present evidence of a constitutional violation insofar as she failed to prove that Isaiah Holloway was acting as a state actor at the time of the incidents alleged to be unconstitutional. And any alleged constitutional deprivation was not clearly established because neither Holloway nor any reasonable officer, knowing what Holloway knew at the time, would have considered the sexual interactions with appellee to be the sexual harassment in violation of the equal protection. As the court's probably aware, we can jump to either one of those prongs. With the court's indulgence, I'd like to jump straight into prong 2, which is the knowledge that the constitutional deprivation was clearly established. The district court solely relied on the September 9th, 2020 decision of Sampson. This reliance was error, as the alleged constitutional deprivations occurred in late 2019 and early 2020. There is one allegation, to be fair to the record, that there
is a factual dispute here because she says late in 2020, correct?
I believe the record is fall of 2020.
Right.
She alleged that there was one final, well, let me be clear. The sexual interactions between the two, 4 of the 5 occurred according to her, late 2019, early 2020. She does allege there is a final sexual interaction in fall of 2020. However, that sexual interaction, according to her own testimony, was in Wenatchee, which is 2 hours south. It was not when Officer Holloway was in his patrol car, in his uniform. It was behind a Costco. There's really nothing to give rise to the idea that he was acting as a state actor at the time of that fall of 2020 sexual interaction.
What about the text messages that occurred in December of allegedly in December of 2020 and early of January 2021? And I raise that because obviously there were allegations of sexual contact, but why wouldn't the sexual nature of the text messages also potentially fall within the auspices of Sampson as a sexual harassment claim?
Yes, Your Honor. 2 points there. One, this is a Rule 56 motion, or it was below. It was not a Rule 12 motion. So the court needs to be looking at the evidence, not the allegations in the complaint. And evidence implies that the evidence should be admissible. And here, respectfully, Your Honor,
we're on interlocutory review. So we're not here to weigh evidence, and if there's a little bit of a gray area around this, but I think we may not even have jurisdiction to review matters that just as to going to the weight of the evidence. So it wouldn't. I mean, don't we have to take plaintiff's allegations as true and then determine in the light of that, under qualified immunity, whether there's clearly established law?
well, here's what the plaintiff can allege. The plaintiff can allege that that she sent, and these are, it may be a distinction without a difference, but they're Facebook messages, not text messages. Facebook messages carry with them a different layer of authentication that may be problematic here, especially in light of the fact that the Facebook messages are sent not from Isaiah Holloway, but from a different Facebook account under the name of Jacob Jones. And then some of the Facebook messages are sent by an unknown user that even plaintiff's forensic computer person couldn't determine who they had actually come from. So in terms of authentication, there's really nothing to show that they come from my client. But even if this court is to take take plaintiff at her word and say that the Facebook messages did come from the client. If you look into the nature of the Facebook messages, there's really nothing in the incoming messages that could be construed as sexually harassing. I would venture to say actually quite the opposite is true. The Facebook messages from Ms. Ortega, at least in my determination.
I think the difficulty is, I think you have a very cogent explanation of everything, and that may be the end result. But there's two issues, it seems to me, with the qualified immunity appeal. The first is that we can't weigh the evidence on color of state law under Johnson. So that seems to me, for better or for worse, that's out, and eventually the district court will sort that out. So then you get to the question of, well, just pure qualified immunity. And now you're pointing up shades of interpretation. And, of course, we do know that sexual harassment does violate equal protection because it's assumed to be gender-based. So that's the constitutional violation. It seems to me the question here is, in the face of this record, could we say that there's qualified immunity? And that's where I'm having some trouble in thinking, well, it's the classic, in this particular case, in light of the allegations, it's got to go back for fact-finding and a trial.
But the question would be, when was the constitutional violation clearly established under the 14th Amendment equal protection claim? Because a number of the claims that are akin to the fact pattern here were decided under the Fourth Amendment seizure. It wasn't until Sampson in September of 2020 that this court expanded the equal protection analysis outside the context of a school or an employment environment. And in that case, even Sampson only extended it to social services. I've yet to find a case that really extends equal protection claims to law enforcement services, especially during the time period at issue here, which would be late 2019, even through 2020, if we want to include the time in which the Facebook messages were exchanged. So
we have the general principle about sexual harassment being gender-based violence, so that's a constitutional claim. I don't think we have to have it applied to a specific category of individuals. So I take your point on Sampson. It's kind of unclear. I mean, Sampson's 2020. We have some allegations, as you point, fall and maybe 2021. So I don't know that Sampson, is any kind of slam dunk for Ortega here because of the timing, but we do have that other principle. And so it seems to me that it boils down to a factual dispute because we got a timing issue and we have a substance issue. Substance meaning the content, and you point out some of the difficulties with the content, but doesn't that just underscore the whole factual nature that would require a remand?
I think when you carve the facts down to what this court, and we're not asking the court to reweigh facts. I guess we're asking the court to perhaps take different inferences from the facts that the district court record establishes. But when you look at the facts, our position would be pretty much anything before September 9th of 2020 that's alleged in this claim would not give Defendant Holloway notice of the constitutional violation in light of the language in Sampson. So then we're just looking at what happened after Sampson, and we're looking at the one sexual interaction that occurred off work, out of uniform. Ms. Ortega herself had to drive 2.5 hours south to meet Mr. Holloway behind the Costco. And I guess I should just say for the record, my client denies all of this, but I understand you have to take these facts.
We totally understand.
Okay, all right. That interaction, I think, under the rest of the case law, and perhaps going back to prong one, which is, was this actor acting under color of state law? There's really nothing in the case law, especially the cases like Dang Vang, Ricky R. Those cases are much more flagrant than someone meeting behind a Costco in their off time. In addition
How about
to
the encounters before September.
For the encounters before September 9th of 2020, the encounters before Sampson, we would argue under the second prong that there was no clearly established right under the Equal Protection Act, under the 14th Amendment, which is the only claim.
But we don't, the Supreme Court says that you don't need an identical case. You don't need a twin, so to speak. What reasonable officer wouldn't understand that it's unlawful
Well, I think
to engage in this kind of conduct?
Understood. What I think the officer did not understand was that he would be acting under color of state law. That's what I think the officer would not understand, and that's based
Well, that's a whole
on
different. That's a different
issue.
That's a different question.
In other words, it might be a constitutional violation if I were acting under color of state law, but I don't think I am.
Sure.
But that is a question that's got to go back to be determined. So,
Well, then let's look at Boyd versus Benton County, of course, a case that I think this court's familiar with. You know, in that case, that was an excess use of force case, but that case addressed whether the use of flashbangs could be, whether an officer would be entitled to qualified immunity for the use of flashbangs when there was no case on point that said flashbangs were excessive use of force, but there was a case on point that said the use of firearms was an excess use of force. Even in that case, the court said you can't just rely on the fact that there's new technology to shield you from qualified immunity. However, that court said we're looking at the other cases around the nation, and the other cases around the nation are saying this is actually a reasonable use of force.
right,
So
but this is
it just can't
this
be
is
defined at too
sex.
high of right.
we don't really need a lot of technology on this one, right?
Yeah.
What about Fontana? I mean, I know much of the analysis turned on the fact that it was a Fourth Amendment claim because it was in the context of an arrest. But there was quite a bit of discussion in Fontana and in footnotes about how normally police-related interactions that involve sexual harassment or something worse is analyzed under the 14th Amendment. And the court discusses out-of-circuit authorities to that. So could that supply enough of a clear law in this context?
I don't think so, because I think this court addressed just that issue in Sampson. I mean, the court sort of resignedly said, we don't want to find...
But that was a social worker,
Right.
sexual harassment. And so that's, I don't know, there weren't really many cases related to that, to a social worker interacting with a public-facing, in their public-facing role. But there have been cases of officer misconduct in this circuit and other circuits, where they've stepped out of bounds and shocked the conscience under a Fourth Amendment understanding. So why couldn't Fontana be something a little more clear for us to be guided by?
And I think the fact that the court is using the term a little bit more clear is perhaps where the issue lies. Unfortunately, this court's been sort of slapped on the wrist quite a bit from the United States Supreme Court at defining clearly established in too high a level of generality. So in this case, I think, again, I don't want to keep coming back to Sampson, but I will. I think Sampson is sort of the poster child for why and how this court wants to proceed on issues like this in the future. The court in Sampson didn't seemingly want to permit qualified immunity, but it did, and then it said affirmatively going forward we're going to apply it in these certain instances.
But why wouldn't, given the ambiguity of the facts and the inferences, even if Sampson were the only case, why wouldn't that defeat qualified immunity?
I think it would defeat qualified immunity specifically for anything that happened before September 9th of 2020, and I think maybe my position would be anything after September 9th of 2020, which I don't think it's clear in the record whether the final sexual interaction occurred before or after September 9th, but the position would be under the, going back to the first prong, whether or not that's clearly established as of Sampson, going back under the first prong, none of the factual allegations there would give rise to a person acting under color of state law.
Thank you.
Thank you.
Good morning. May it please the court. My name is Tyler Hotchkiss, and I represent the appellee and cross-appellant Vanessa Velasco. The review in this matter is de novo, with all inferences to be drawn in the light most favorable to Ms. Velasco. This case is about common sense and what it tells us about the actions of Mr. Holloway. In addition to common sense, Holloway was on clear notice via case law that his actions would violate the constitutional rights of Ms. Velasco and other women that he preyed upon as a detective and as a deputy of the Okanagan County Sheriff's Office. It's common sense that you, as an officer, cannot have sex with someone who is a suspect in a burglary you are investigating. It is common sense that you, as an officer, cannot have sex with someone who you found in possession of stolen property within weeks of having been in possession of that property. Of note, Ms. Velasco was never charged with a crime related to the burglary or related to the possession of stolen property. It is common sense that you, as an officer, cannot hold charges over someone's head and have a sexual relationship with them. Pursuant to Ms. Velasco's testimony, that is what happened in this case. It is common sense that you, as an officer, cannot have a sexual relationship with someone while on duty, in uniform, knowing their history of drug use and criminal involvement. Just weeks prior to the first sexual interaction between Ms. Velasco and Detective Holloway found Ms. Velasco at a known drug house with a meth bong with drugs in it. Additionally, Deputy Holloway had arrested Ms. Velasco prior to this. Deputy Holloway had found or known about drug involvement in addition to the interaction at the drug house. And so,
counsel, what do you think is the best clearly established law to support Ms. Velasco's claims?
I think the court hit on really all of them. Okay, I think Fontana is a great case. I think one of the problems with these cases, as the court might recognize, right, and as Hess recognizes, is that sometimes they're analyzed under the Fourth Amendment. Sometimes they're analyzed under substantive due process. Sometimes they're analyzed under equal protection. In my mind, those distinctions don't matter. And here's why. Is because if the same act involve multiple constitutional rights, notice of the act itself being unconstitutional is enough to establish the violation of the constitutional right.
And would you agree that with respect to the specifics of Sampson, that it would only constitute clearly established law post-September of 2020?
No, I don't think that Sampson is the limiting factor here. In other words, I don't think that Sampson starts the clock.
That's really not my question. My question is with respect to invoking Sampson as a source of established law. We can't look before September of 2020, can we?
I'm not sure I completely understand your question, Your Honor, but if your question is whether there's any other case besides Sampson, then certainly there is. If you're saying, does Sampson, I think Sampson certainly adds to it, right? Okay. But I think if you're looking at
leaving aside Sampson, you're saying Fontana, what else?
West versus Atkins is a Supreme Court case. It's a case involving the Eighth Amendment, but it does involve equal protection as well as sexual conduct related thereto, and I think that establishes that's one of the cases that the Eighth Circuit looked to in, apologies, the name of the cases, in Johnson versus Martin, when it established that a abuse of authority over non-employees on the basis of sex was clearly established in 1999, is what they said, right? And so, Your Honor, I think West, along with Johnson versus Martin, I think Dang Vang is another case where this idea of whether is it equal protection or is it substantive due process. I also think that's one of the reasons, Your Honor, that this court should invoke pendant jurisdiction in this case, right? Is because these two items are intertwined. Because, back to my original point was just as a hypothetical, Your Honor, if you have a unreasonable search and seizure, let's say a strip search in the middle of a public road, right? But that strip search is based upon sexual motives. You have two violations at that same time, right? You have a violation of the Equal Protection Clause, in my mind, because they're disparate treatment because of sex, and you also have violation of unreasonable search and seizure. And so both of those acts, if there was a case on point like that, would serve as the basis for proper notice and clearly established law.
I think. Go ahead.
Go ahead.
So you've now moved into the area of your cross appeal, but if we were to determine that you can't you can't look at the color of state law because of jurisdictional problems, but you can look at qualified immunity. And if we were to determine, as I was discussing with Ms. Kuhn, that there are these factual issues, that there is a baseline, but there's factual issues sufficient that you got to go back for trial, it would seem to me that it would be inconsistent with that to then say, let's take there should have been pendant jurisdiction on the substantive due process claim, and we should affirm the district court on that, because we're talking about the same underlying factual basis. So I'm not sure how we would do that without having some kind of legal and factual inconsistency.
I don't, Your Honor, I appreciate your point. I don't think that's what the George case says. I think the George case says, and I'll admit it's in a footnote, right? But the Ninth Circuit says in the George case that, look, the same legal standard and the same facts is the circumstances, especially under qualified immunity, that would allow us to invoke pendant jurisdiction. And other circuits have.
Okay, well, let's say we did, but then what I'm saying to you, isn't there what you would basically say is that the district court granted summary judgment on the substantive due process, correct?
Correct.
In your favor?
No.
Not, I mean, in favor of the county. So you want us to reverse that on appeal now?
I want you to reverse the fact that it's because what the district court found is not that there was not a constitutional violation, which I think is what you're getting at. What the district court found is that the law wasn't clearly established related to substantive due process. And so those two things are not inconsistent in my mind. Those two things are completely consistent, especially where you have, as here, the same acts that invoked two different constitutional violations.
But I guess for pendant jurisdiction, it's not just that there may be overlap between claims or issues,
Sure.
but that one is inextricably intertwined with resolving the other.
Sure.
And I just have a hard time seeing how we have to resolve a substantive due process issue in order to resolve the qualified immunity, equal protection issues that are before us.
Yeah, it's a good question, and I fought to some extent with this in my mind, but in the end I couldn't get around it, and it's this, that if there is notice as the one constitutional violation, now I don't think the court has to find that here. I think the case law, especially in George, says same facts, same law, same parties, they're inextricably intertwined. But if that does not satisfy the court as far as pendant jurisdiction goes, I think the finding of the same act, going back to the strip search analogy, right? The same facts constitute two separate constitutional violations, then you do have pendant jurisdiction, because if you're on notice of one constitutional violation, then you're on notice, right? It's not like we're taking a different set of facts. I think to rule otherwise, Your Honor, would be splitting hairs for no particular reason. Let's assume
I don't know that the Supreme Court would agree with you. I mean, when it talks in Casella or other cases about not staying at a level of generality, of having to be more specific, I don't think the court would say that just because a certain act might result in different constitutional violation claims, that the court resolving one makes it interchangeable with another, right? I mean, why does that make it clear to an officer on the scene that if I'm violating, let's say, the Eighth Amendment, that it would also violate the 14th Amendment?
the purpose of qualified immunity, of course, is to put the officer on notice that his conduct is illegal. We don't want people running around suing officers who may not understand what they're doing is illegal or unconstitutional, maybe is more accurate. And so in this case, if the same act invokes two separate constitutional amendments, I think he's on your notice. You satisfied qualified immunity because the same act in two separate scenarios, the same act violates two separate constitutional violations. You are on notice, officer, right, that this particular act, strip searching in the middle of a street, a woman for sexual reasons, right, that you're on notice, and it satisfies the purpose of qualified immunity.
So I couldn't find it, but can you point to any case where a court has exercised pendant jurisdiction on interlocutory review for qualified immunity?
Your
'Cause I
Honor,
looked and I couldn't see it.
there was two cases. The Ninth Circuit said it was possible. That doesn't answer your question. The Hudson versus Hall did, it's a 10th Circuit case, did exercise qualified immunity, pendant jurisdiction on qualified immunity in two separate circumstances. In one separate circumstance involving two separate rights. One was a Fourth Amendment attainment, and one was detainment, and one was a Fourth Amendment search. And in that case, they ruled on both matters. And then I think that there was one other case.
Well, you can tell me later. You can tell the panel later if you find it later.
It's a Jackson case, Your Honor. I'm sorry, and they didn't actually invoke pendant jurisdiction, but they did indicate that if the party had cross-appealed, because they didn't cross-appeal, that they would have invoked pendant jurisdiction in that case. And that's the Jackson case. I'm sorry, I don't have the full name of the site here in front of me, but it is cited in the materials.
So tell me, in your view, why Sampson is... Let's talk about Sampson just alone for the moment. Why is that clearly established law in the context of this case, in your view?
Your Honor, I think it just follows a long line of cases, including Atkins and other cases that hold that in this scenario, that using your power, governmental power, to abuse or coerce somebody into sexual activity or sexually harassing them in that context is clearly established. I think Sampson, in conjunction with a lot of other cases, I think Sampson, in conjunction with the 10th Circuit case that we referenced
We can't have
earlier.
any conjunctions with. It's the problem. Has to be clearly established.
Sure.
For an officer in the Ninth Circuit.
Sure, and Fontana does that as well. But Sampson was one of the cases that did that as well. Fontana, Dang Vang, all of those cases make it clearly established that you cannot use your governmental power to sexually harass or abuse women. But, Your Honor, I think even beyond that, my point in listing off those original cases and common sense, as I stated, is to Your Honor's question, which was, wouldn't any reasonable officer just know that he can't have sex with a known drug addict while the criminal charges are pending, that he can't do it in his uniform in a patrol vehicle, that he can't do it while she's high?
So let me ask you this. Isn't
Sure.
this one of those unique cases where Hope versus Pelzer may lead the path to a decision in this case?
Your Honor, I'm sorry, I don't know.
Hope?
Yeah, I don't know Hope. Yeah.
Well, you might want to go take a look at it.
Okay. And my apologies, but
Oh, that's okay.
Yeah. Just being 100%.
It was an Eighth Amendment case where the prison officials put this fellow in a cage in the yard and left him there.
Okay.
There was no case, but the Supreme Court made it. In that one rare instance, the Supreme Court said, this is so obviously wrong, you don't need another case.
Yeah, and Your Honor, that's what Fontana says, right?
And that's from the Supreme Court. And the Supreme Court, although the Supreme Court has made it pretty clear, you need to be able to point to something. But they haven't completely said you need an identical case or you need something that's on all fours.
And I agree, Your Honor, and that's what Fontana says. Fontana says, look, there's no legitimate governmental purpose in sexual harassment or sexual assault, and that's the exact case here. There is no no functional governmental purpose. This is malum per se. This is the case that it's so patently obvious that any reasonable officer would know that this is unconstitutional, that it's on, to me, that's the biggest point as we sit here.
Thank you very much.
Thank you.
Good morning, Your Honors. I think I asked for 5, but I think I have 2 left. I'll try to keep it to 2. Briefly going back to the appeal itself, this court asked, does the Hope case essentially control here? And again, this is specifically to the equal protection.
I didn't use the word control. I just said, my
Guide?
guide path, the decision-making process.
Sure. I think the question essentially is, isn't something so inherently wrong that the officer is on notice of it regardless of whether there's a point or a case directly on point? And here, if that was the way that the court could look at an issue like this, I think that the issue in Sampson would be, or the ruling in Sampson would be very different. Counsel wants to collapse basically notice of one type of constitutional violation is notice of another type of constitutional violation. In Sampson, I think if the court was able to use that type of analysis, and if the court had used that type of analysis, they would have said, well, this was clearly, the officer was clearly on notice that that was unreasonable under the Fourth Amendment, so we're just going to apply it to the 14th Amendment equal protection claim. And the court didn't do that, so I think that's oversimplifying the analysis that this court has inflicted upon itself. But turning more to the point, again, you can't define this in terms of a level of generality. So if the level of generality is, well, isn't this just inherently wrong? You'd have to look at why the decision was in Ricky R. the way it was, why the decision was in Roe the way it was. I mean, those were sexual encounters between a state actor and a minor. I mean, those are almost more offensive than the facts of this case.
Could you address what would happen if we were to disagree with you on the qualified immunity on the equal protection? How would you analyze then the cross appeal and whether it's inextricably related factually?
And I think it may go back to the same type of analysis that I just articulated. You cannot, at least I've never seen this court collapse the analysis quite like that and say that, well, the analysis for the 14th Amendment equal protection claim is very similar to the 14th Amendment substantive due process claim. So if we decide one, we're essentially ipsy dixit deciding the other. As the court pointed out, I've not seen a court exercise pendant jurisdiction in that fashion. I also looked, I couldn't find anything.
I haven't found anything, but we're using those little words inextricably intertwined, and it's the same facts laid out.
It's the same facts, but it would be a different legal analysis and a different type of notice to Defendant Holloway. I mean, there's a different line of cases for equal protection as opposed to substantive due process, as opposed to Fourth Amendment. Frankly, I was sort of surprised that if counsel was going to move on a cross appeal, I'm surprised it wasn't under the Fourth Amendment, a granting of the Fourth Amendment claim, because I think the seizure claim is a bit more similar to the equal protection claim. But now that we're here and we're under substantive due process, that claim is even more far afield from equal protection than the Fourth Amendment claim.
I mean, in a way, I guess we're all wrestling with what box to put these things in. And at the root of all of this is, I take counsel's point, it's an abuse of power from an office is the allegation, where whether you're under arrest or you're a public servant and you're abusing your office in order to do something sexually inappropriate, crossing a line. Why isn't that inextricable in the end between those two things?
Sure, and I think the court's use of the term box is appropriate. I mean, in the federal context and under the amendments and under the 14th Amendment and the different causes of action available under the 14th Amendment, they are boxes, and they are different types of boxes. Plaintiff's not without a remedy. She still has her WOLAG claim. She would still have a number of state law claims, but inherent in the 1983 analysis and the qualified immunity analysis is this analysis that was Holloway put on notice that his violation was unconstitutional, and specifically unconstitutional as it relates to the specific cause of action. So that's why I think we have to analyze those things separately.
Okay. Thank you. I think we are done with our questions.
Thank you.
Counsel, thank you both for your very helpful arguments. The matter will stand submitted.